You're listening to the Place Northwest podcast, your digital resource for the latest insight and analysis on all things property in the northwest of England. Listen when you want, where you want.
Hello, I'm Sarah Townsend, editor of Place Northwest. Welcome to this Place podcast sponsored by the award-winning law firm Kuits. Based in Manchester, Kuits specialises in real estate law, including commercial and residential property, construction, disputes, planning, licensing and property finance. Today we will ask the question, how has Covid-19 affected the construction industry? And what should developers and contractors do to prepare for the future? Our guests today are Charlie Tomlinson, Head of Construction, Engineering and Energy for Kuits, and Mark Bond, Director of Quantity Surveying Infrastructure at construction consultancy Sime. The pandemic has caused disruption across the whole industry. And as companies start preparing for the lifting of restrictions following announcements last week, there are still so many unanswered questions, of which the legal aspects are key. Our guests are well placed to tackle this subject. Charlie is a lawyer in construction and engineering procurement, acting for developers, contractors, utilities and funders for major projects throughout the UK. And Mark has 25 years' experience as a contract and commercial manager. He's also a qualified arbitrator and focuses on dispute avoidance. So, over to you, Charlie and Mark. You've got questions to ask each other, I know, but may I start with this broad brush one first? What do you think the current restrictions on movement and social distancing mean from a legal perspective? Are they regarded as law?
Shall I kick off on that, Mark? I think the problem there, Sarah, is that they are not. They are still being billed as guidance, and the latest guidance that came out on the 7th of May, much eagerly anticipated, because this was supposed to be the construction industry back to work document, makes it very clear all the way through it that it is a guidance and recommendation. It also says quite clearly it's a non-statutory guidance, but government is encouraging the parties to follow its recommendations. So we're still in the territory of non-statutory guidance, which is a bit less than helpful.
Yeah, it's a very interesting point you make there, Charlie. It is guidance, but we're in a situation, I think, where there isn't statutory authority, and it isn't a relevant event insofar as the contractor is able to claim for it. But this is an exceptional circumstance. So, from the contractor's perspective, I think we need to perhaps look at this guidance and look at the government to reinforce it in some way so that it can be used to act in a fair and a reasonable way, which is again what the document talks about. And it talks about maintaining productivity and maintaining payments and really preserving the construction industry and it's specific about that, rather than entering into formal disputes.
No, I think that's right, Mark. And I think for the purposes of our chat today, I'm going to take the developer position, if you like, the client position. Like you, I act for both sides, so I do see both sides of the argument. But from a client's perspective, as we all know, it is the common sense approach to work collaboratively, and if ever there was a time for that to be more than fine words, it's now. But the difficulty is with projects that are starved of cash and are being sort of compressed between funders at one end, not releasing additional funding, and contractors at the other end requiring much needed support. It can sometimes be the developer or the client in those situations who's caught in the middle of this, and that's when it's difficult unless there's very clear terms from government as to quite what's supposed to happen.
Yeah, you're absolutely right, Charlie. It's it's an interesting situation, isn't it? It's all very well the government giving us guidance and saying that the parties, the developer and the contractor, should act in a collaborative fashion to reach a resolution. But ultimately, if projects, as they already have been significantly delayed by the COVID restrictions, ultimately, who's going to pay for the prolongation? And it's questions like this, I think, which the industry wants some answers to. You know, there is, contractual provision in most of the main contracts, certainly in NEC and JCT, to claim under force majeure. So it enables contractors to perhaps obtain the extension of time they need because of COVID, but it doesn't give them money. So again, we get back to a situation where we want to comply with the government's wishes, and everybody wants to complete projects, but it is going to come at a cost, and who's going to pay for it?
I think that's right, Mark. And it, just picking up on your point about the NEC forms of contract, this was always billed by the government over many years as being the collaborative form of contract, which was supposed to avoid disputes at all costs. And my experience has always been that that's great during, good times, but actually when you really need it, which is now, and these are completely it's not trite to say, these are completely unprecedented times. If ever you needed collaboration, now's the time. But one of the difficulties I'm experiencing when I'm acting for client is that they're saying to me, a contractor may be able to claim a force majeure event as a result of COVID. Is there anything in this in the contract to protect me in relation to those potential claims? And one of the areas I've looked at and spent quite a bit of time focusing on in relation to JCT is that obligation in there to, even if it's an event that would entitle you to an extension of time, the contractor has still got to use his best endeavours to mitigate the effect of any delay. So I've got situations where contractors shut down sites on the 23rd of March, and clients are saying to me, well, that can't be right, can it, Charlie? Because if there's a requirement to use best endeavours, then simply shutting up shop and saying you can't do it is not complying with those requirements. So my starting point would be you've got to actually demonstrate that you've actually taken pretty serious steps to try and keep the project going.
Yeah, no, I absolutely agree with that point, Charlie. Yes, the contractor must, use his best endeavours, but again, we are in exceptional circumstances, and using best endeavours is one thing where we might look at alternatives to supply materials or alternatives to procure materials and to procure labour, for that matter. But one is very mindful of the contractor's obligation to also comply with the health and safety regulations. So, contractors have a duty of care to make sure that their employees are safe and not subject to any unnecessary health risks and so on. And ultimately, this means that if you're going to comply with the guidelines, as most, if not all, contractors have, it means that rates of productivity go down. So using best endeavours is not as easy as it was. So, I think we need to look at alternatives. What else can be done? Bearing in mind the latest guidelines from the Cabinet Office, what can be done to reach, an amicable settlement in these sorts of situations? And, one way might be to look at reprogramming of the works or operating, 3 different shifts in 24 hours or something along those lines. These are sort of things I think the industry needs to consider.
Could I come in here and ask in contracts then what other clauses might the contractor rely on, for those sorts of alternatives as a remedy to further delays and just disruption with the projects? Are there any other possible solutions?
Yeah, well, I'll touch on that one, Sarah. I mean, we've talked about force majeure, which is the obvious clause, if you like, to look at, certainly under JCT, and in NEC3 and NEC4 it's slightly it's disguised. It doesn't actually refer to force majeure, but it talks about prevention and events occurring that are beyond the party's control and unforeseeable, which is effectively the same thing. But there are other compensation events that the contractor can look at. For example, he can look at the supply of materials. He can look at the supply of labour. Especially in a situation where that might be by the employer. There's a whole list of different options that he can look at.
Yes, I mean, one of the difficulties, I've seen quite a number of these arguments put forward, and obviously I wear different hats depending on who my client is. But one of the big stumbling blocks that contractors have got, of course, in relation to the supply of materials and labour, is the wording of JCT and to an extent NEC and most standard forms. They didn't really anticipate this type of crisis. So it talks about strikes and lockouts, and it also talks about the actions of government actions, and I think the government's been quite cute in a sense in not taking the step of making sort of mandatory pronouncements, and as a consequence of that, the difficulty contractors have is actually getting their claims to sit nicely under one of those headings. And it does require sort of cooperation, I think, from the employer side to say, actually, yes, we understand that your supply chain is disrupted. We understand that there's going to be a claim for additional time. We actually need to sit down and try and and I would say for the good of the project, try and work out a way of keeping things moving, because the natural end to all this in many cases is that we will see significant contractor insolvency, where they simply can't finish the job without more money.
Yeah, and that's that's absolutely right. And if you refer again back to the latest guidelines issued by the Cabinet Office on the 7th of May, it talks about protecting the UK economy, and it talks about maintaining productivity, and it talks about maintaining a healthy business and being able to deliver construction projects and maintain levels of productivity, which is all great, but the guidelines are changing, and we have to look at the situation where potentially these restrictions could be in place for many months to come. We've already seen the furlough scheme extended to August, October, possibly, and these are going to give real significant delays to some of the contractors, and they're going to be looking for money. And if there isn't some sort of money, or at the very least, a release from liquidated damages, we are going to see more insolvency, and that's not going to help us, is it? So the question arises: what do we do in the future? How do we deal with this?
Well, one of the things that I've been doing, Mark, is with clients who want, and I'm glad to say it's most of them, want for the good of the project to protect each party's position. We've actually been entering into collaboration. I've entered into 2 or 3 collaboration agreements, and what these have done is sort of almost suspend the strict contractual provisions around time and money, and have effectively introduced a sort of COVID period, where in that period there's a requirement to be very open in terms of program delays and additional costs, and come to the table with actual costs that have been incurred as a direct result, and those are going to be considered and looked at with the aim of keeping the contractor going. And so far, the 2 of those that I've got in place are working reasonably well. But you quite rightly say, Mark, the longer this continues, the more pressure the project's going to be under.
Yeah. I mean, collaboration is a fantastic thing, isn't it? As long as the parties collaborate. So one would hope, given that there's some guidance on this from the government, that this strict contractual approach to construction contracts might be relaxed, by mutual agreement to some extent, and that contractors really think about the alternatives of how they can deliver these projects. For me, there's various forms of dispute resolution available, and guidance says that we don't want everybody going into a dispute, and we don't really, because disputes cost astronomical amounts of money, as you know, and they are very destructive to the parties and to the future and delivery of the project. Behaviours and mindsets can become very contentious. So, I spent 15 years of my career dealing with claims and disputes, and really the last 10 trying to avoid them. So, I really welcome this guidance. I think it's a great opportunity for contractors and developers to sit down and look at doing things differently. But you're right, particular things need to be done, and claiming actual costs as opposed to costs plus might be one way that that's done. And this really sort of brings us on to preparing claims, I guess, and looking at the program and making sure that as there's various component parts to preparing a claim. And the first and starting point is the entitlement. Well, that has been relatively straightforward by looking at the contract clauses and what constitutes a relevant event or what's a compensation event. But we have the COVID situation here, so this area especially is very grey. So this is where we need some sort of concession between the parties to get started.
Mark, are you just to rewind a little bit? Are you actually seeing a rise in disputes, sort of starting, bubbling at the moment, or is this just a sort of, if people don't follow and take on board the guidance and put in place the measures that you're describing, that you're
I think,
we could see?
To answer your question, Sarah, I think the answer is yes. I mean, it's inevitable that there will be claims. Let's call them claims at the moment under the contract, because claims are still areas where we can reach amicable settlement. It's a claim under the contract, but it's not a formal dispute. But certainly, I've had inquiries from developers asking me, what should we be doing? What do we need to do to prepare for this in the future? We know that the contractor's going to be looking for more time and more money, and what can we do? And so, my answer really is to make sure that there is a robust procedure in place to look at the records, what's actually happening, making sure that the contractor is keeping his records, and really that the employer is doing the same thing, the developers are doing the same thing. So in particular, the program is key to this. So what, we're talking about cause and effect now, really, aren't we? So COVID is the cause, and the effect is the disruption and delay to the program. Now, if the contractor is doing that and preparing his extension of time or his compensation event under NEC 3, that's great. But unless the employer is in a position where he can actually check and verify those records, again, you've got potential for a dispute. But if the parties cooperate and they, follow the guidelines to avoid a dispute, and everyone's got the evidence in front of them, and everyone's got, their man on the or woman on the job, as it were, then it should be easier to reach some sort of settlement.
I think that's key, Mark. I mean, one of the points here is trying to untangle the pure COVID-related delay position from earlier issues. I mean, I've got two issues at the moment that immediately come to mind where I'm instructed by the developer and the project was already in delay. And in one of those cases, the developer has now used COVID as its get out of jail free, or it seems, to try and claim back all its delay. Now, what that's done is that's caused quite a bit of ill feeling with the client, who's saying, I'm happy to look at the COVID element, but please separate that out from your previous delay. The other case is quite interesting, because what they've said is, yes, we accept we were in delay already, but we were rather hoping we were going to accelerate. And because of COVID, we can't now accelerate. So actually, the whole delay is really due to COVID because we wouldn't have had a problem. And I think that's where it starts getting difficult. And I think very much the parties have got to try and come to this in a less adversarial way. So from a contractor's point of view, I would say they've got to try and come in the spirit of openness to say, these are the issues I'm actually experiencing. And this is, it's almost like an open book approach. This is the time, this is the cost. What can we do with it? And from a client's perspective, they've got to weigh up very carefully. Do I play the strict contractual card here and say, you can have some time but no money? Or we don't think you're entitled to time because we don't think you've used your best endeavours, and then force either a stalemate or a dispute, which might ultimately lead to adjudications and may ultimately lead to insolvency, which, sure as anything, is going to cost more than trying to keep the contractor going at the moment.
Yeah. I think there's a couple of points there just to sort of raise, Charlie. One is, delays before COVID. I think contractors, in the spirit of mutual cooperation, or whatever you want to call it, have to hold their hands up, really. And you'd hope that we can identify what those delays were, prior to COVID. So, there typically might be something to do with design delays, or it might be something surrounding access to the site, or it might be mobilisation, or whatever it is. Those delays, I think, have to be dealt with, separately, effectively. Contractors can't, and I've already heard contractors saying, "Oh, this is terrible. It's a terrible thing, but it gives us a get out of jail card." I think that has to be kind of cut off at the pass, if you like, and so any delays that occur in the program have to be looked at and identified and agreed between the parties. And then the delays that have really occurred since March the 23rd, when Boris made his speech, have to be dealt with separately.
I think that's right. The other issue you've got from a developer perspective is the attitude of those upstream, and in the main here, I'm talking about banks who are funding the development. And I'm involved in projects where the banks are quite rightly scrutinising any claims for additional time, and the same for agreements for lease with institutional tenants. And they're saying, well, unless you can really demonstrate a robust case, why should we put more money into this, and why should we allow more time? So I think it's a case of trying to get agreement throughout the whole of the supply chain.
Before we start to sort of wrap up, because we're approaching the end of our slot, do either of you have sort of further comments to make, specifically about the effects that the pandemic may have on new construction contracts or those about to commence on site? So rather than existing ones, ones that are actually coming to the foreground.
I'll start that one if you like, Charlie. We talked about force majeure previously being the sort of obvious opportunity, if you like, for contractors to claim time, certainly against their existing contracts. But moving into new contracts, one as a defence to that would be that, well, it wasn't unforeseeable. Everybody knew about it. So I think we need to build some provision into new contracts, whether that's a specific compensation event or it's a relevant event in a JCT contract, to enable the parties to deal with the whole COVID restriction issues, because otherwise, we end up in the situation where we've been debating so far, that the parties are encouraged to come to some sort of amicable settlement because there isn't really a contractual clause to hang your hat on. So I think that, and you can tell me what you think, Charlie, that we should draft something into new contracts for it.
I think that's right, Mark. I think one of the problems you're going to have is that the existing contracts in their standard form don't really reflect the risk that COVID is creating. Therefore, you're going to either not be able to get into contract because the parties simply cannot agree a risk allocation under the standard forms of contract, or we're going to have to look at some significant amendments to try and introduce some of the spirit of the Cabinet Office guidance going forward. Now, a couple of things do come to mind here, Mark. One is, what if in 3 to 4 months' time, in some sort of miracle, everything's going back to plain sailing, and then you've actually got a contract where the risk profile doesn't quite fit the actual circumstances. So I wonder whether you have, as you say, some specific bespoke arrangements for dealing with the effects of COVID for as long as those particular effects are impacting on the contract. I think that would be my first point. My second point would be, and I know it's something you and I have talked about, Mark, is whether we have a different form of dispute management process, which looks at avoiding parties running off to adjudication, which of course is their statutory right, but actually looks at dispute boards where it might be QS, lawyer, named in the contract, who are able to be light on their feet and try and resolve things amicably very quickly, so the parties are actually able to move on in a collaborative way. Because if ultimately you're reliant on existing dispute resolution provisions, I think in a sense we've failed, and I think that's going to be bad news for the industry.
Yeah. I mean, I think the key to it is having some flexibility, isn't it? And that flexibility can be written into the contract in terms of a specific clause, I'd suggest. But like you say, Charlie, the problem arises where you'd almost have two situations, wouldn't you? You'd have a construction program, business as normal, if you like, and you'd have a construction program assuming that we have COVID restrictions for the foreseeable duration of the contract. But what you need is a mechanism where, let's say, the restrictions are part lifted or completely lifted in 3 or 4 months. How do the parties deal with that? And I think that gives that sets the scene, if you like, to enter into the discussion. But then I think using DABs, dispute boards, is an excellent way, in my view, to resolve a particular issue or a particular delay that's occurred because of COVID. So, like you say, the parties would choose some professional bodies that are impartial to either party. So you might choose, like you say, a lawyer. You might choose someone like me from a construction consultancy, and depending on the nature of the work and the sector, you might choose an engineer, or you might choose, a delay analyst to look at the program. So, it's a developing situation, isn't it? Really.
And I think it's an opportunity for the industry. I think it's the biggest issue the industry will have faced, certainly in my practicing career. And I think it's an opportunity for the industry to really embrace it and look at different ways of contracting. Because if you don't, then what I think will happen is that parties will say, well, we can't actually enter into anything new, any new contracts, until there's certainty around COVID. And that, I think, would be horrendous for the economy, particularly for infrastructure projects, and really unhelpful in terms of bringing us out of this problem. But I think it's going to require multidisciplinary approaches: lawyers, engineers, cost consultants, being creative, imaginative, and collaborative to try and keep everything moving, keeping the wheels on the wagon.
Yeah, absolutely. I mean, we're going to see a new dawn around collaboration, I think, aren't we? I think, as you may have said earlier, NEC3 was always, or NEC4 really was always designed to engender that collaboration between the parties and to deal with issues and to resolve them. But largely things do tend to get left longer than perhaps they should, and they do fester. We now have W3, don't we, in NEC4, which enables dispute boards to move into operation. And in the greater good of all this, we've got a seriously wounded economy at the moment, which we need to get up and running as quickly as possible. So, it has to be collaborative.
Absolutely. I've got one final question of my own, a brief one, really. I mean, going right back to the beginning of our conversation, you both mentioned how the current guidance is not statutory, it's not enshrined in law yet or at all. Do you think we're likely to see any new legislation enacted, put into place as a result of what people have learned throughout this lockdown and this pandemic?
I think it depends on how Sarah. I think it depends on how the industry responds to this latest guidance, and also the ease with which sites can operate safely. I think the government recognises that the construction industry is such a major part of the industry that it really needs to use all its powers to keep it up and running. So I suspect they will want to keep a light touch rather than trying to legislate because of the inherent difficulties of doing that. But I think some of the guidance may find its way into more formalised regulation if it looks as though the parties are unable to find their own way through it.
Okay, we're going to have to wrap up there, but what an interesting and very useful conversation. A note for our listeners, Charlie and Mark will be running a follow-up discussion via Zoom to give developers, contractors and other industry professionals the opportunity to ask questions and share opinion and best practice on the topic. To register interest for this event, listeners should visit www.kuits.com/events or email Sarah Glynn at Sarah, SarahGlynn@kuits.com. Finally, I've been Sarah Townsend, editor of Place Northwest. I'd like to say a big thank you to our guests, Charlie Tomlinson at Kuits and Mark Bond at Walker Sime, and also to our listeners, and we hope to see you again soon.